Hey everyone, Harry here to talk about the Supreme Court's last opinion today. It's the same one that was mistakenly issued for a few minutes yesterday, which is a story in and of itself, but it's the Idaho abortion case, and it's quite a story. And the opinions themselves, what they show about divides in the court, all a big story. But let's talk about the case on the merits first, and then I think I'll do another tape on a couple of the opinions because I think they really bear closer look. All right, so the case. The case concerns the conflict between federal law and state law. And what's the state law? Idaho passed a statute in the wake of Dobbs saying you can only get an abortion to prevent a pregnant woman's death. That's, about as severe as they come. And this is the first state law that the Supreme Court has considered since the Dobbs case itself. But the way it came up to the court is interesting and ends with a whimper with today's opinion. So that's what state law provides. What does federal law provide? It says, hey, if you get Medicare funding from us, you've got to give the right kind of care to Medicare patients. And that means in emergency situations, you have to undertake, regular, appropriate medical care. And that means there's this whole area. Part of the argument in the case is it like this or is it like this? In which women are in grave need of medical care in emergency situations, but not circumstances that seem to be you need an abortion to prevent a woman's death. So you've had these incredible, ghoulish horror stories that came up at the court argument, in fact, with women, having terrible medical issues with pregnancies and just not getting treated in Idaho because it doesn't look as if it's necessary to prevent death, but it would have been necessary to prevent, for example, infertility for life, terrible kinds of, ongoing problems, women who needed emergency medical care and couldn't get it in Idaho. So that's federal law and that's state law. And the feds, when Idaho law was passed, sued and said, you can't do that. You've got to follow Medicare regs. Plus, we preempt you. Federal law is supreme. And that was the argument. And the district court agreed and so stayed, the operation of the Idaho law while it considered it. So it said, we're putting it on ice because it looks like it's wrong or it's preempted and the equities are on the side. The whole inquiry you do to stay a case. And then they made the stay permanent. It went up to the Ninth Circuit, which was considering it. And at that point, the Supreme Court reached out and grabbed the case before the Ninth Circuit had finished deciding it. A really sort of remarkably aggressive thing they do. Remember, Jack Smith asked them to do it in the immunity case. They didn't, and then they took it after the D.C. Circuit. So here they reached out and grabbed it. That was pretty aggressive, but they dissolved the stay in Idaho. The Supreme Court did over really vehement dissents. They made it the case that Idaho law was applying, notwithstanding what seems the contrary commands in federal law. Okay, so that's how things stood until today. And what happened today? Point one, we're talking about these kinds of cases, really emergency ones. And point two, the way the Supreme Court actually dissolved the stay. And after it did, it meant that women in Idaho, they were being airlifted to other states regularly every week. Something that had happened only once the year before to deal with these medical problems. Okay, Now, point three is a little bit Supreme Court inside baseball, but important. They sometimes will take a case and then they say, when they look at it more closely, we shouldn't have taken this case. And there's a special writ or order that they give, which is to dismiss a case as improvidently granted. We shouldn't have taken it in the first place. That's what they did with this case. Now they said, oops, never mind. Sorry about that. And so it went back to status quo ante, as the lawyers would say, where it was before they entered onto this misadventure. And that means, among other things, the stay is in place. It also means, among other things, the Ninth Circuit can finish. It can go back up to the Supreme Court, and they can still decide on the merits whether to let the Idaho law go into operation. At least for now, women in Idaho who have emergency situations are getting care again. All right. The actual opinion in the Supreme Court is on the question whether to dismiss it as improvidently granted. And you had 5 people who said, yes, you should do that. 2 of them, Kagan and Sotomayor, said, as we told you then, this case you should never have entered the stay. We should never have granted this. It's plainly a conflict with state law. It's plainly preempted. They did not come close to making the showing that they're likely to prevail, which is what you had to do for those. So for those reasons, the whole thing, like we told you so, it was totally mucked up and improvident to be doing this case at all in the first instance. So that's what they said, and that's so let's just get rid of it. Then there were 3 more, Roberts, Kavanaugh, and Barrett, and that's, you're going to see all these post-term analyses. Do we have a new center with those 3, et cetera? And they said, they didn't join Kagan and Sotomayor. They said the case has changed since we took it. It looks a little different. And why is that? It was because in arguments before the court, you had the Idaho saying, we're not so bad as all that. There are cases where, death is likely, but there are ways in which women who, are not on death's door can get treatment. And the Fed said, we actually have, we're not so permissive as all that. We interpret it stringently. So in other words, the 3 of them could say what looked like this sort of case now is that kind of case. Should that matter? I can't see it, because first, for those people, and whether it's here or there, it's the same issue of law. And second, this is a case, remember what they said is it's improvidently granted. We messed up. We shouldn't have done it. And what these 3 were saying, and I think it was, just a kind of a way of getting the case the hell out of there, just a real, eyesore of a case. But what they were saying is it looks a little different. It's changed. That's literally the way they put it in the opinion. So it's not what we thought it has changed. And that's not what improvidently granted means. Improvidently granted means at the time we, hadn't really worked it through. So that's a little bit, I would say, dodgy, but nevertheless they did it, and that amounted to 5. And who'd that leave? The 3 arch conservatives who wanted to just pedal to the metal and take the case and keep the stay and basically decide for Idaho, and Justice Jackson, who said, look, now that we have this, we should go ahead, but obviously from the other view. Both of those vantage points, I think, are really interesting. And since this case now is just in a position where it can come back again, it's just that the stay has been re-entered, those positions are going to potentially matter quite a bit. So that's the story. It's dismissed as improvidently granted, so sort of wiped from history, never mind, except the positions are really sort of auguries of what could be coming in the Supreme Court as soon as next term, or if not this case, another one, because these Medicare regulations obviously apply generally to any hospital that takes Medicare funding. So there you go, but with a little bit more of a deep dive on the Jackson opinion and the Alito opinion, I'm going to do another tape right after this. But bottom line is it's all dismissed like it hadn't happened, and it's back in the Court of Appeals with the district court stay in operation. Talk to you later. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.